Good morning, everyone. Good morning, Lauren. Good morning, Emile McPhee. How are you, Emile?
I'm good. I'm good. Staying warm.
Very
Yeah.
great. Lauren had to move her heater because her feet were cold. It was blowing out the audio a little bit. So
I know.
Emile is joining us from Hamilton Locke. You're a new partner at Hamilton Locke, and Lauren and I met you at a social and affordable housing event in Sydney earlier this year for the first time, and we're sort of reconnected recently. And you've got a really interesting background, Emile, particularly around the SDA and social housing environments. And when we caught up last week, I thought we've got to have a chat on the podcast and share some of this, because we do come across so many legal challenges in the SDA world, and not just from retail investors, where you sort of might go, okay, it's pretty tough. You kind of expect some wrong turns from retail investors, but a lot of smart money has made some wrong turns in SDA. And look, you've got again, I'm just kind of glancing across to your bio over here that I've looked you up, and you've got some really high-powered credentials. Are you still on the board of Jacaranda? Is
I
that
am.
still
Yep.
yeah?
Excellent.
Amazing organization. Yep.
Yeah, you led the finance on a 475 unit build to rent collab with Queensland government as well. Yeah, so there's some
Yep.
really relevant experience, and I'd love to sort of hear from you a little bit about your background and what you're really interested in.
Yeah. Thanks for having me. So I'm a property and finance lawyer. Don't hold the lawyer against me. I promise we're not all bad. I've been working in the sector for about 10 years now, and started my journey in housing with retirement living, things like that. And then over time transitioned into social and affordable housing and specialist disability accommodation. I really love both of them because there's a clear purpose to everything that they do, which is fantastic. But then also it's so complex, these areas. There's a lot of tips and tricks and traps that can befall even the most sophisticated players, as you were saying. So it's something that's really interesting to get involved in. As you said, I'm on the board for Jacaranda Housing, which is a tier 2 community housing provider here in Queensland. So that's really helped me develop the sort of understanding of the practical realities of some of these decisions. I think one of the challenges from the legal perspective is that you can come in with a very sort of uncolored lens, just looking at the pure law, but until you get into the nitty gritty and the actual understanding of what's involved, you can be missing quite a lot. And had an opportunity to be involved in some really amazing deals, including the one that you mentioned, the Build to Rent project, but also community housing project up in Cairns that had both community housing and specialist disability accommodation.
Is that the old drive-through one? The old
I think
drive-through.
so, yeah.
Yeah, that one. Yeah, I'd love to sort of. I didn't know you worked on that until just now. I'd love to talk about that one a bit later as well. But no, you've covered off quite a lot, and it sounds like you said you've been doing this for sort of 10 years. You put a lot into 10 years. What stands out for you? What's been your favourite thing?
My favourite, I'd have to say the Cairns project was one of the most amazing. It was a really interesting project because it was such a sort of diverse spread of things, different product going in, couple of different types of product in terms of social housing and specialist disability accommodation, different funding streams, things like that. So that one was an amazing. I must say one of my favourite other ones actually was acting for an SDA provider on a development here in Brisbane that they were doing with an institutional partner. And I think my favourite one on that is that it was one of the earlier ones that I'd been involved in from an SDA perspective and got to be involved from the get-go. And then recently, I think it was end of last year, got to go out and actually see the homes being finished and built.
Right.
Which a tip for anybody in the market, lawyers love to get out and see the physical product. I want to go and walk around, see the design, see the building, see all the features. It's amazing to get to put that into context.
Yeah, the trouble for guys like me and people like Lauren is that we're going to pay you travel time there. You got to walk around the site, travel time back to the office. That's why we don't take you to site, mate, because you.
Don't forget the taxi fares to and from as well.
Yeah. But it is really nice to see something from start to finish.
It is.
And the bit that I had a nice reminder of that recently too is, from conception all the way through design, construction, and then vacancy to tenanting, and then going back to see the property fully occupied and really operational and doing what it was meant to do, and meeting the families and the people that are in there and just seeing how it works. It's really it helps bring, the why we do these things full
Yeah.
circle. So it is a great thing to do, and it's worth the travel time. So I
Yes.
encourage you to push for it.
I promise, David, I won't charge you on the travel time.
Mate.
That's my property developer head coming back,
Yeah.
and I see the invoices and go, oh damn it.
Yeah.
We swapped some emails about a podcast today, and there's some things you sort of touched on that you've seen that that are interesting to talk about. You mentioned the interplay of state and federal laws,
Yeah.
and there's so many changes. I say to people all the time, and I think we might have even discussed it when we caught up last week about the NDIS market. It's a maturing market, and the laws are changing, the ideas are changing, the strategies are changing, and it's becoming more mature and evolving. And that seems to be happening quite quickly at the moment with all the top-down pressures on the budget and the bottom-up pressures from just cost of living in life. And how do you say how do you see the state and federal laws interlacing and working with these rapid changes? Because policy often takes a lot longer to change than what's happening, right?
Yeah, exactly. I think one of the challenges is this is a very consumer protection focused area, as it should be. And I don't think anybody would suggest that we need less protection for participants. One of the downsides of that is that it means that there's really complex overlays and interactions. And while you can, have the best of intents, if those things aren't worked through, it just creates a really, at times, unworkable situation for providers and those who are dealing with the sector in trying to understand and properly implement the arrangements. So I think a good example of that is the Queensland residential tenancy law changes that came through earlier this year, announced last year. But those in particular introduced sort of a prescribed application form and then restrictions on information that could be collected from prospective tenants. No carve-outs or recognition for SDA providers whatsoever, so they're part and parcel of everyday and mum and dad or institutional landlords. But of course, when we're looking at this, SDA providers are providing a very specialised and much needed service to people with significant disabilities. The fact that you can ask for 2 documents relating to the suitability of the property for a participant, I don't know many SDA providers who would be able to capture all the information that they need to properly assess whether a property is suitable for a participant in 2 documents.
No, and the challenge that we have with that is that it's not only the RTA legislation on what we can and can't collect, but it's also our obligations as an NDIS provider.
Exactly.
So we've got to do both. We've got to meet compliance for both legislative pieces. We wouldn't want to do less than what was best practice. You know yourself that there's so many things that go into, is this property actually right, and is it safe, and is it the best option for this person?
Yeah.
Certainly can't just be a financial assessment for that person's pension and rental contribution. It has to be a functional assessment, environmental assessment done by a qualified professional.
Yeah.
Otherwise we'd be doing everyone a disservice, and people would be moving in and out of properties because they're unsuitable.
Do you know, terrifyingly, one of the suggestions that I actually heard, and this wasn't a sort of off the cuff thing, was, can you just sign somebody up to a tenancy and then figure out if it's the right one for them afterwards? Which I'm going, what an absolutely horrible outcome for a participant. Somebody moving into this home and then being told, actually, no, that this home's not right at all. Try again.
Or not. Whether you're a participant or not, what a stupid idea for any human being. Like,
exactly.
You don't move into a place and work out if it's good or not. You got to get that work. I have an opinion which might shock Lauren to hear, that I have an opinion about some of this stuff. And so before I colour my opinion a bit, how do you feel that this new government in general is doing in the disability space? When you hear things like this, because it's a Queensland law that's sort of been changed and doesn't quite work, and then there's other areas where government decisions impact people with disabilities. How do you think they're doing? They're 7 or 8 months in now.
Look, I think they're still catching up. Somewhat understandable. 7 or 8 months in, it's still a short amount of time in political terms. I think there's the right intentions behind a lot of the things that they're doing and investigating. It's now a matter of sort of properly understanding and listening to the sector in terms of what the issues are and how they can be resolved, and then trying to implement those. The problem is, I think that's going to take another 6 months at least. to start flowing through properly.
I noticed
Yeah.
on your discussion points today the separation of SIL and SDA. So we're looking back at the review recommendations from 2023 now, and the fact that they still haven't been implemented, and that there's not necessarily a rush to do so, which you're right, might not be a bad thing because we want to do it properly when the time comes. But it's absolutely something that, we're starting to see movement in the industry for, is that separation of SIL and housing. When do you think that's going to come about, and what's your view on, a mechanism that might be able to separate that out in a sort of organised manner?
Yeah. Look, to be honest, I don't have the crystal ball on when it might happen, and to be honest, I think I'd be surprised if it's in the next 2 years, really, because, I just can't see it moving, getting the traction that it needs to really move quickly. I think some of the issues are, obviously, there's some providers who are sort of set up more in a way that can facilitate separation reasonably simply now. There's a lot of other providers, particularly smaller, more regional, rural type ones, where that kind of separation might be completely overhauling the way that they've sort of established themselves and do things now. And I worry that with a quick implementation, those providers and the services that they offer in already sort of very difficult to manage areas might be made worse.
Yeah, I think there'll always be a proportion of the regional providers that will suffer with the generalised sort of fix that they do for the rest of the industry.
Yeah.
Just given the lack of options, lack of staff, it's always been a problem, no matter whether it's housing or support or allied health, So yeah, that's a given. But 2 years is long, Emile. I wanted you to say, by the end of the year they'll have it out, and this is what we've been hearing.
Look, I mean, maybe by the end of the year we'll have a path forward. How about that?
That's great. I'll hang on to that hope.
Yeah. I'm not sure. It's already July. Oh my gosh, it's August now.
It's August
So
today.
I'm not sure how
the
much.
1st of August today. That's right. Yeah. Hence the heater under Lauren's toes there.
That's right. It's off now. It's off. Queensland's starting to warm up already.
Yeah. But I think the problem is I've already had some discussions with SDA providers around the separation. But I think while we're not sure at the moment sort of how far up the chain it has to go, what degree of separation do you need? Can you sort of share some resources? Can you have it under a parent company, or does it need to be fully separate? If it's fully separate, can you share the board, or do you need a fully independent
that's interesting too, because there's a lot of tricky things you can do with entities that legally they're different entities, but practically it's the same person. So does that mean intention of separation of services?
Exactly.
Probably not.
Yeah.
Right.
And that's in some ways I go, hopefully we don't go too far into, you can't have any of the, we shouldn't end up in a situation where you can't have anybody the same, that kind of thing. But working with providers, it's difficult to tell them sort of here's how you could structure it now, unless they're willing to go to a sort of fully independent model, because anything else might be a partway step that really just adds an additional step in the process that isn't going to actually benefit anybody.
Yeah, I think we deal with a little bit of this now as SDA providers, and I think what you're talking about then introduces lots of stakeholders in the participants circle. I've been doing some work with our team, and we can have participants who might have sort of 12 stakeholders around them.
Yeah.
And when there's an issue at the house, there's 12 people all want to get involved, and it's really as a provider, it's really challenging to coordinate all of those people who rightfully have a view and an opinion and insights, contribution, and it's just then trying to unpack whose voice needs to be listened to right now to get, again, in the property space. We're not talking about direct supports here. We're talking about in the property space to get something repaired or fixed or moved, or it gets complicated. So now if we're talking that separation of service, it may result in several more stakeholders in that circle that need working with, right?
Yeah.
It is tricky.
Already, and I think, Lauren, you've said this before in a previous podcast, but it's complex, but it's important. The problem is neither of, we can't just go, let's simplify everything down to have nothing, because it's really important. We've got to sort of set some boundaries, set some parameters. But the more you do, the more complex it gets.
Well, You mentioned in one of your notes, about SDA providers. Again, you look across a lot of providers, and you've seen some providers that maybe forget that participants are still tenants as well.
Yeah.
And something that we've been discussing just this week, actually, with I've had a chat with our board and some of the team about it, is some of our SIL providers that work in our homes.
Mm.
SIL providers, in the traditional SIL model, they might own or rent a property, and kind of people can come and go, and they just manage that, and they work out rooming, and they kind of catch up the paperwork. Maybe
Yeah.
they're a bit fast and loose with some of the documents, like move in, then make it work, kind of thing. And we're seeing, and that doesn't work for us. We're like, listen, we've got to be compliant. Because as a provider, we get audited, and if boxes aren't ticked the correct way, then we're in strife. And we've got some of our SILs will just move someone in, and we find out about it days or weeks later that there's a new person in the house, right? I mean, what are your thoughts around that? How would you encourage managing a situation where a SIL kind of forgets that they need to follow a certain process, and they just start moving people around?
Yeah.
And try and catch it up.
Well, I think it's very important to have a well-drafted and thought-through collaboration agreement between.
Very good. Yeah.
I say it in jest, but also in reality. But one of the downsides to the collaboration agreements is that you'll often see, I've seen ones that run for 80 pages, and nobody, I can assure you, is going to read that or remember it. But I think it's around making sure that at the outset there's clarity on whose roles and responsibilities and who gets to call the shots on certain things. The interaction, particularly between SDA and SIL providers on tenanting and vacancy management, always seems to be an issue that, while people, I think, might believe that they're on the same page and understanding, once you start drilling down into sort of whose got what role in the piece and who gets to make choices and things like that, it turns out that you've got entirely different points of view.
Yeah.
And I think if you haven't figured that out up front, you're never going to make it work when things are happening.
It's a good point, that communication and expectation management at the front of the process. 'Cause if someone, whether it's an SDA provider or a SIL provider or a support, whoever, if somebody places a participant in any home who's the landlord doesn't know they're there, there's no rooming agreement, there's no tenancy agreement, they're squatting.
Yeah.
Right. By another name, you might, and that should be a reportable incident to the Safeguards Commission. That should be. I would have thought. Would you think that, or?
Oh, I always worry about how much should be reportable because of the impacts that it can have. But yeah, I think, well, it certainly to me shows a real disconnect and failing in the relationships that are going on. And the problem is that just leads to massive differences and sort of falling outs between both the providers, but then also the participants. It's not an ideal outcome for anybody.
No. And we have run into circumstances like that where the participant placed slightly early prior to paperwork being completed has been a really good fit, and there have been a certain amount of discussions around it, and we work it out and are able to sort of massage the documents to make it work. However, there's also been cases where, the person moved in has actually created risk for the other people, and it wasn't assessed properly, and it was done under duress, and it was a really big mess. So I think it really relates to the risk associated for the participants involved. And it really, like you said, it comes down to communication. So you're right, collaboration agreements, communication up front, and making sure that the staff actually involved in that process are across it and understand. That's a big thing.
And I think the last thing you want there is as well, that terrible situation where there's risks, it's not working, and then somebody has to move. As we said before, on the sort of move in and figure it out later, that's a terrible approach.
As an SDA provider, what we see is trying to untangle a situation like that post-event. It's incredibly resource intensive, and it can really take up a lot of time from our property managers. And so there's service degradation impacts down the line where we're not looking after other participants and clients because we're trying to unmess a mess that shouldn't have been made in the first place. So that's it's just it's a business kind of, how do we sort of resolve this kind of thing? This project up in Cairns that I did want to talk about. I've had the opportunity to speak to some of the senior people in the housing department about it, and I've looked into the funding and how it was all put together. And you're clearly going to have a lot more insights on this. But the funding it looked complicated because there was quite a few stakeholders involved, and in the conversations I've had with the senior department people, so they explicitly in the grant, the funding, 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 the fund component of that project excluded any SDA. I think there's 30 or 40 SDAs in that project. There's 490 units total, and I think there's 30 or 40 SDA units within the project, and they were explicitly not funded by any government money. And I've looked deep into this in the past 12 months, and there's a problem definition I didn't understand, and did some work, and we've established this year that Queensland is the last state or territory in Australia that doesn't categorise specialist disability housing as social housing. I've challenged the housing minister with that in a meeting. I said, hey, we're the only guys not doing this. We talked about it, and we all agreed that SDA, it meets the definition of social housing.
Yeah.
And that's why other states and territories have gone, this makes sense, we should include it in our definition of social housing. And what that allows them to do is then to include SDA funding for CHPs,
Yeah.
they go for grants. So in Queensland, CHPs can't get any grant funding to build SDA because it's not part of the definition.
Yeah.
What's your commentary on something like that?
How absurd. I look at it and just think, it's the housing diversity we need. There's no reason specialist disability accommodation shouldn't be included. I think it comes down to this sort of vision or view that, federal funds SDA, state funds the other things, never the two cross. The problem is, particularly when you're dealing with CHPs, they do need that capital funding component, and they do create these fantastic diverse communities. Like, why not have in a large development some specialist disability accommodation? But when you say to providers, yeah, we'd love for you to do that, just go fund it all yourself, it sort of goes, well, how's that meant to work, and why? I've never ever understood the rationale behind it as just being
I don't get it either. And
federal versus state.
to be really honest, the interactions I've had with the senior bureaucrats, and I'm talking to DGs and ADGs at that level, and the minister, the interactions I've had from the bureaucrat side, they've been quite belligerent about, I don't know, the Fed funds.
Yeah.
And I'm like, the Fed doesn't. Sorry, the Fed pays SDA, but they don't pay money to CHPs to build this stuff.
Yeah, exactly.
Because it's social housing, and Victoria's worked it out, WA's worked it out, New South Wales has worked it out, and they all now have really good programs where they fund SDA. Indeed, Victoria, the Victorian government is the largest SDA provider in Australia, the Victorian government. And at the minister level, he was like, well, why is this looking into it? And I just last week I got an email back from one of the senior guys in the department saying that there's no intention right now to adjust that policy. So they're going to, that's how it's going to stay for the foreseeable future, is they're going to ignore SDA and exclude it from social housing. It's really frustrating.
Yeah. And I mean, hopefully we've got, new master agreement for CHPs coming out. And I think there's some sort of movement at least to explore the alternatives of whether it's pure social and affordable, giving that sort of alternate revenue stream to help subsidise the social. So hopefully maybe as we start to see some movement and changes there, there'll be a continuing evolution and recognition that, we don't just need to provide this one precise form of housing. We do need to provide all of it. And look, I can understand perhaps from the government's point of view that they don't want to sort of go off and fund just a whole lot of pure SDA for SDA providers, no connection with but I think that can very easily be managed. That's not something that needs to be worried about or a sort of roadblock to the arrangements.
Yeah, no, great. I have another question for you, given your experience and some of our previous conversations. We had discussed the old Residential Tenancy Act versus Management Agreement in SDA. And I know that you're a bit of a specialist on this. So I just wanted to give you the floor and ask you to sort of unpack some of the nuances of providers that are either using one combination of both. Like, what are you seeing in the industry as best practice, and what are the biggest risks on doing it, differently? Yeah.
So is this around the agreements with participants or agreements with property owners, or?
I would suggest agreements with participants.
Participants, yeah. So I think in that one, it goes back, Dave, I think you said it earlier, participants are still residential tenants. They're still sort of offered and have all those protections. The acts still apply to them. And so I think, it's a matter of making sure that you comply with that. In that case, I always sort of go, I think from my perspective, the best and easiest solution is usually to use a tenancy agreement, then adapted with sort of some arrangements, whether it's special conditions or an associated services agreement that fleshes out some of the SDA rule provisions.
yeah.
The problem is, I've seen people do it sometimes really well and sort of it creates a nice document. I've seen one that was 65 pages. I went, no participant in their right mind is going to be able to read this and understand. I couldn't even understand it. I think, hate to spruik Victoria, but I think they've got the best situation because down there, the state government's actually gone through the effort of recognising that specialist disability accommodation exists and that it's a bit unique, and developing their own agreements and own sort of rules around that. I would
That
love.
is really cool, actually. Yeah, it's really great what they've done.
Other
I think it's because they're the biggest provider in the country, though.
Yeah.
I think at a government level, they understand the challenges, and it would have been looking internally.
I look at it and go, well, Queensland, New South, like other jurisdictions, the work's been done for you. We can see how it can work, and that it does really work. It makes a much simpler, easier framework for both participants, but also SDA providers. Because this can be a real confusing area, and I have seen some who'll just go out with a pure sort of service agreement that really sometimes doesn't even talk to the tenancy component at all. And I just think that's such a risk because there's risks with not complying with the residential tenancy laws. But then also it's just not clear to anybody what the arrangement actually is. But again, at its heart, it's just a tenancy with the SDA overlay.
Yes, and we find that having that Residential Tenancy Act sort of behind the service agreement or in front, whichever way you look at it, is really, it's important to protect the rights of both parties. So it's important for the tenant to make sure that the provider is doing the entry and exit condition reports so that they have that standardized practice so that when they leave, they can call upon, standards and things to be met and maintenance and all that stuff, as well as flipping it back the other way, that the owners have got that buffer of a bond being collected and rent in advance being collected and, maintenance being dealt with within certain timeframes and privacy, notices for entry and all of that stuff that comes along to protect the structure of a tenancy really is important. So I personally don't see how it can work without it. So just a management agreement or a service agreement that's got a couple of references to tenancy in it, and absolutely see the need to have both. I think my unsettledness just in the background there is just about those special conditions and making sure that across the industry, having some standardized terms in there that would help support all providers to maintain a sense of expectation and application across the board. Victoria, again, we fall back on that. And I've looked up those agreements and had a good look through them and sort of tried to utilise as much of what has been done and is working down there in that model to incorporate up here in Queensland, because I think it's really important. And it's an insurance for both parties, which is, what we're there to try and protect is the interests of both parties and the property. And that structure does that really well. If you get the special terms right.
Yes. And I think that's why I really like the Victorian model, because they integrate it all together. The problem that you get with special conditions or associated services agreements is that you end up with things just look different, and that's jarring to the eye. But you end up you can't just build it all together into one nice cohesive package. It ends up being sort of quite disjointed at times and just difficult to follow. So to be honest, half the time that I spend on whenever I'm doing those kind of arrangements is less on the drafting and more on just the visibility, how easy things are to follow, how easy are they to read and fill in, because that's the other problem. I've seen some that, may tick all the boxes, but they're so convoluted in terms of, you've got to fill stuff in on pages 6, 12, 18, and the final page that nobody does. And, you'll end up with an agreement that's actually not really worth much because it's blank.
That's an interesting area because, you're speaking towards efficiencies and making things simpler and flow better, right? And I think if you talk to any of our staff at the moment, they're kind of sick of me saying, how do we simplify this? How do we simplify it? Because there's a lot to do then, and I'm sure that there's chats in the background about me going, I wish you would stop.
Never.
But I think, take Lauren's idea and let's just make industry standard ones. Why have separate ones for each individual provider? Like, it doesn't benefit anybody. And there's nothing real. Some providers might have some different things that they want to focus on, particularly from past experiences. That's sort of always a driver for what goes into those. beyond that, which could very easily be dealt with by some minor special conditions, beyond that, everyone's dealing with exactly the same things. So I see no reason why each provider needs to go off and develop their own.
Yeah, yeah, yeah. No, agreed.
That's
We
really
we
great.
have-
So Hamilton Locke's going to generate the industry standard document set. Change the
Absolutely.
name at the top, charge them at $20 a document, and we're all happy.
Yeah.
Everyone's on the same set.
I
Right?
hear
Perfect.
that you have a nice, complicated state by state legislation. You told me that you have that lovely
I
resource.
did. It's
but
color-coded and everything.
You're the guy.
yeah.
You're absolutely the guy.
Unfortunately, though, I think it comes out to be about 10 A3 pages.
Right. So,
That's a bit scary.
Emile, if I'm listening to this podcast and I'm a CHP or a SIL or an investor looking to do a retail or industry investor looking at SDA, what can Hamilton Locke do for me? What questions should I be asking as someone in that situation towards someone like you?
Yeah, help with anything. To be honest, the main bits that come up that I think need to be considered properly and often aren't, tax. It's always the driver, and I've seen many structures sort of come undone or be flipped around at the last minute because of tax issues and people not properly thinking through how that works. Funding is the other piece. These things don't get done without money, unfortunately, and trying to figure out and understand what the funding sources are, what their requirements are.
It's changed a lot in the past 10 months. Funding since late last year is the landscape's just different now.
And then obviously also all the property and licensing stuff, depending on the structure that's used, you can come unstuck on many little bits and pieces. And the problem is, particularly if you're sort of replicating things at scale, you'll end up with sort of one minor thing that goes wrong, but then you replicate it 200 times and you end up with actually quite a large issue on your hands.
Yeah.
And an expensive fix at the end of the day rather than a sort of, proper consideration at the start that, while it might take some time and thinking, it's so much easier than trying to unwind.
Yeah,
Yeah,
and
I think with professionals like yourself, Emile, when people ask me, do you know someone who can help with X, Y, Z? I say, well, what's the problem you're trying to solve?
Yeah.
It's, if you don't see an oncologist for a bone sprain, right? You see there's specialists, right? And you've clearly got some specialities inside this SDA and social and affordable housing world. And I think if you're looking to get involved in that space, you don't go to your family generalist solicitor.
Yeah.
You've got to find a specialist, got some experience. It's the same as architects and builders. You want to find architects and builders with experience, background in building these homes, lawyers with experience in this space, accountants with experience in this space. You've got to get the right team with the experience.
Yeah. So definitely encourage anyone trying to figure out all these complicated little SDA nuances to give you a call, because the discussions we've had have been really enlightening and very helpful.
I'm glad. And likewise, I love getting to hear all the practical realities of everything that happens, because again, I think it's just such an important consideration.
Yeah.
We can get it right on paper sometimes, but so wrong in practice. And if the two aren't lining up, then it's not doing anybody any favors.
That's right.
Yeah, and this is where we see people take a wrong turn. On paper, it stacks up because there's so much information out there available on the internet, on paper, on documents, and you can make all kind of sense in your brain. You can run a feasibility assessment, it all stacks up, and then reality.
Yeah.
The wheels are falling off.
And the problem is then, well, actually, I should, I'm sure our litigation team would love the work that comes there, but my goal is to keep as much away from them as possible, unfortunately.
Thank you. That would be great.
Well, look, we're almost at 40 minutes. It just flies by. Well, let's do this again though sometime. Like, let's just give it a few months and then we'll find some changes and come back.
Hopefully there'll be some stuff we can talk about on SIL and SDA separation for Lauren pre-2026.
I would love that, pre-2026 being the key, and I'll hold you to that. When it all starts rolling out, we'll unpack and see if our crystal ball was right. Hey?
Yeah, this is unfortunately recorded, so can't even backtrack on what I said.
No, I should start.
Well, guys, thank you very much for this morning. We'll end it there and we'll get this out over the weekend, I hope, or certainly by Monday. So thanks, Emile. Thanks for joining. Thank you for your time. I really appreciate it.
Thanks,
really great to pick the brain of an expert with some experience like you've had and some big projects and really great insights. And Liz, good to see you. We're off now. DHS has got a wellness afternoon this afternoon. We're doing some work with a charity, and we're all about to spend a couple of hours together trekking through the inaugural reservoir on the north side of Brisbane. As a team, and doing some presentations about health and fitness and things like that. So we're looking forward to that. Good afternoon.
Well,
Yeah.
stay safe. Have fun.
Yeah.
Thanks, everyone. Bye-bye.
Thanks, guys. See you soon.